The organization Undoing Tax Abuse says the contentious Road Accident Fund Amendment Bill will not address fraud, corruption and claims backlog. The Law Society of South Africa joins us in studio to give a legal perspective on the draft legislation and to also react on RAF CEO Collins Litswalo's recent comments on the bill. Advocate Lizelle Haskins joins us now for more of this conversation. Lizelle, a pleasure to have you in the show this afternoon. Firstly, maybe a good starting point would be to look at the bill itself. I mean, what are your thoughts on removing lawyers as middlemen in the claims process? Do you believe it will genuinely simplify the process for claimants?
Thank you very much for having me. I think the first thing that we've got to look at is what the current regime is that we have now.
Yes.
So in terms of the current act, there is an opportunity. In fact, there is a process that is available for road accident fund victims to claim directly. The only reason why they're not claiming directly or why that has not been successful is because the road accident fund itself has been struggling to manage and deal with the claims. I say that specifically for two reasons. I think the first one is they are unable to successfully assess the claims, and secondly, they are not in a position to properly make the payments in terms of the claims. Now, if the direct claim system as we have it now was to work, then there would be no need for lawyers.
Yeah.
If what they are proposing is to have more direct claims without the lawyers, and they are in a position and capable to actually administer or assess the claims and make the payout successfully, then there would be no need for lawyers. The reason why there is such a high, or why there is so many litigation or cases within the courts, and why the attorneys and legal practitioners have to get involved, is because, one, you would find in fact, I'd done some homework in preparation for this evening, and a colleague who runs a firm says he had a claimant who had directly claimed for his minor child who was 2 years old.
Yeah.
The minor child had sustained a severe brain head injury. Instead of assessing the claim, the Road Accident Fund had actually repudiated the claim. It was that necessitated the parents to get the attorneys involved in order to institute and lodge the claim successfully on behalf of the claimant. So the necessity for the lawyers arises out of the conduct or the inability of the Road Accident Fund to be able to assess those kind of claims. And so in order to have, or I think maybe the bottom line is that the Road Accident Fund must be able to demonstrate that they can actually do it without the lawyers, and that then takes away the need of having lawyers. But until then, it becomes imperative for a lawyer or the lawyers to get involved so that they are able to ultimately assist Road Accident Fund victims.
Time and time again, we do hear claims of lawyers themselves abusing the system or even trying to enrich themselves through some of these claims. Give us your own observation on some of the reports that we've received.
Can we say that there hasn't been one or two or small pockets of lawyers that have been unethical?
Yeah.
We can't say that. I think you find that in every different profession. You find that as the CEO of a public entity that you would find, even you'd find that there. But I think the general brushstroke or the general statement about lawyers in general being unethical, I think is an irresponsible statement to be made. Because the majority of us take the ethical oath and actually vanguards of ethics within the court. And so for us, it is our responsibility to ensure that we don't mismanage or defraud or bring false claims to courts. And so with that, we then obviously say that the statement or the narrative that's being punted by the Road Accident Fund, like I said, is irresponsible. Yeah.
So in light of the Law Society's view that the RAF legislation benefits claimants themselves,
Yes.
How do you respond to ARTA's concerns about the proposed bill being unconstitutional or even unreasonable?
Well, I think it goes also back to the beginning. The 2005 amendment was put in place in order to deal with certain unconstitutional issues. And there was the Road Accident Fund at its core has got to compensate or acts as insurance in terms of two levels. The first one is you have the Road Accident Fund ensuring you against personal injury or personal cover in the event that you're in an accident. And the second one is to indemnify the wrongdoer. So when you're indemnifying the wrongdoer, it means that if you can't claim from the Road Accident Fund, you are not in a position to claim against the wrongdoer. Now with the new amendment, there is certain victims or accident victims that are no longer covered. So for example, if someone does a hit-and-run accident, bumps you and then flees the scene, you won't be able to claim against the Road Accident Fund. If you're a minor child that crosses a highway, that minor child would not be able to claim against the Road Accident Fund.
Medical aid as well,
Before we even get to the medical aid, there's that second component. If you're a foreign national properly in our country, you won't be able to claim. If you suffer general damages, irrespective of whether you comply with the new amendment, you will also not be able to claim general damages in respect of pain and suffering. And this is despite the fact that you could have had a severe brain injury or some sort of amputation. And so when you look at the Act as it is or that is being proposed, it is unconstitutional in that it deals with rights of all citizens of the country and to some extent foreigners who are lawfully within the country. And for those reasons, we then say that this amendment seeks to undo what the courts have already declared unlawful. And for the amendment to go through would then at its core disadvantage Road Accident Fund victims.
So the Law Society also emphasizes this global rarity of requiring lawyers for social benefit schemes. How does this unique requirement in South Africa indeed impact the access to justice and also the efficacy of the RAF system?
I think when you're looking at sort of the impact for lawyers at least, like I'd indicated earlier, we have it's like an insurance of sorts, in that it gives you the cover, both the personal and the indemnity cover, and depending on what side you are. So if you're going to be, if the cover is there, it's an insurance cover, and so internationally, you would require lawyers to participate in insurance claims. And so I'm not aware of as indicated by the CEO, that it's only unique to South Africa, that it's only South Africa that would have a social benefit scheme that is assisted by lawyers. According to my understanding, and I don't know what the research on that is or what the Road Accident Fund has done in order to accumulate that kind of research, but as we understand, that in different countries, as far as insurance claims are concerned, it has been led in the main by lawyers.
So considering the Law Society's criticism of the Board Notice 271, how do you think these additional requirements might affect claimants themselves? And do you find merit in these provisions?
So the Board Notice 207 goes beyond what the current Act reads. So there's certain requirements, lodgement requirements that the Act currently says. So you've got to do a Section 19 affidavit, you've got to do an ID copy, you've got to fill out a RAF 1 form. You also have to have a statutory medical report. What the Board Notice does and what the amendment seeks to legislate is additional requirements that ordinarily might not be within the scope and domain of a particular victim. And three things come to mind. The first one is a hospital record, the second one is an accident report, and the third one is what is called a passport stamp. Now, if we look at the hospital records, that you've got to rely on a government hospital to take meticulous notes and then also to ensure the safety of it. And it's a common feature within the hospital to, one, not have lost the file in terms of the hospital records, or you would have to pursue some sort of litigation in order to retrieve copies of the hospital records. So that then puts an additional burden on a road accident fund victim. Or if we look at the accident report form, let's say, for example, you're involved in a collision, you're unconscious, you then taken to hospital, you wake up days later. And you might not know that you have to actually go and report the accident or that it has been reported. And you would typically find that there are some road accident fund victims that come to court that doesn't have that could potentially not have accident report. Now, to make that compulsory later, and that's not a requirement in terms of the Act, and then to insist that you will not successfully lodge a claim because you don't have these documents, makes it then, again, I think, difficult for a road accident fund victim.
Advocate Haskins, as we wrap up our conversation, I mean, AUTA has also asserted that the new RAF legislation doesn't address the root causes like road safety as well, inefficiencies, and even a lack of leadership within the RAF. How do you propose tackling these issues for a more comprehensive solution here?
For us, I mean, you'll recall I was a guest previously on the problems that we had noticed or investigated within the Road Accident Fund. And I think the problems that we had raised at that time has now culminated to some extent in the proposed amendment. We had thought at that stage it would be useful just to have a conversation with the necessary political heads, being the Minister of Transport, his deputy, and then also the Minister of Justice, including the board. And that has not been, so we've not had any response, meaningful response to that kind of engagement. As an organization led by the LSSA, there's various other legal professional organizations like NATAL, like BLA, the different attorney associations. We had come together in a hope that we'd be able to have that meaningful conversation and say, how do we help, where can we help, what are the problems that we're finding, because a number of the attorneys specifically are involved at that level, at the almost grassroots level. And so they have they have a better understanding of what those issues are, and could help where you're sitting as a minister or a deputy minister, or you at a board level, where you might not be afraid with that. And so it was, let's share information. We think we have some of the solutions. How do we come to find the solutions? But one thing that's quite important for me to share is that in addition to just the limitations of the proposed Act, what is surprising is that there's two additional items of concern. The first one being you now have an adjudicator that becomes compulsory, the office of the adjudicator that becomes compulsory before you can find relief in the court.
Right.
Now that requires significant funding. And where should that funding come from? So you take it away from a road accident fund victim and you put it into administration, and I don't know if that's the best way to use resources. But the second concern is that we have a CEO that now says he wants to be an executive member with voting rights together with the CFO. In addition to that, he wants the powers to appoint and terminate the executive leadership within the...
Is that not giving him too much power?
That is the concern. And when you're sitting in a board level with that kind of power, knowing that the rest of the board is only able to sit for a 3-year term, and because of your employment as the CEO or the CFO, you then have an indefinite period, and so you are a consistent present decision maker within a board, while the rest of the board only has 3 years. That then raises the concern in terms of exactly what you're saying. You might be sitting with too much power, and that power could be used in the wrong way, and we suggest, or we are of the view that it has been demonstrated over the past few years that the Road Accident Fund hasn't had the victim in mind in putting in administration. And also, I mean, of late, you would be aware of the parliamentary committee and the concerns they had raised. And one of the things that the Act seeks to do is to undo the reporting to the parliamentary committee. So one, you're having a CEO with too much power, and two, you're having a CEO that's not accountable. And that, for us, is a huge concern as legal practitioners.
As we sum up our conversation, with the amendments to this legislation coming into, well, not exactly coming into effect as yet, but looking at the drafted proposals so far, does it then, for public perception, does it then create confidence in these new changes that may come through the RAF? Especially for claimants as well. We had
done, I mean, at the stage we had done a count. It was before the 8 October deadline. And there was just over 18,000 comments received from South Africans. In addition to that, there was over 8,000 objections that we were aware of. And so what you find is there's a lack of confidence within the bill because of the concerns that have been raised. It must concern you as a road user who pays his petrol fuel RAF levy, that if you were to fall into the exclusionary categories and you have devastating consequences because of the accident, that you could be without compensation.
Lizelle, let me thank you for your time. That's Advocate Lizelle Haskins, of course, taking us through the intricacies of some of these new changes to the RAF